back to my channel, my people. The IPOB leader has people. Oh, his presence in court was loud because the people was just hailing him and praising him. We already know by now that his presence speaks volume. I'm going to play a short clip where this actually happened. Don't go anywhere, and we'll be right back. Now, my people, you saw that already. Moving forward, remember Justice Omotosho said that on the 20th of this November, that Mazi Nnamdi Kanu's judgment will be pronounced. So now, Mazi Nnamdi Kanu has moved straight to court to do some filings because there are some adjustments that needs to be made in the documents he is with. Let's look at the clip where that actually happened. And don't forget, we'll be right back.
So when you're not in her office, okay. So this is they give a directive that count 7 doesn't exist anymore. So that you should amend it, change it, it doesn't exist. I still play to that 714 law.
Yes, it was an error.
No, big error. So I want them to correct
that. That was one of the motions we asked, that appeal should be set aside.
That's right.
And it has not been heard.
Now that you have seen that, I have a question for you. What is your opinion on Mazi Nnamdi Kanu's filing a new case? Does it strengthen his position or complicate the entire legal battle? Let me know your thoughts in the comment section. Regardless that some mistakes were made in the file given to the IPOB leader, he made 5 requests to the court in Abuja. In this request, he made mention of 1. Clear evaluation of the directive of the Supreme Court's order over his case. 2. An order of court setting aside all the proceedings that was conducted in his trial. So let's not be that I'm the one saying all this. So let's watch the video together. I would be right back.
Nnamdi Kanu has presented 5 requests to the court. The Federal High Court in Abuja, where he's standing trial, he has presented 5 requests to the court. When did he present the request? Recall that the case of the prosecution was closed. Nnamdi was to open the case of the defense. He said he doesn't want his lawyers anymore, and the judge allowed him to defend himself. Okay? On one of the occasions when the matter was adjourned for Mazi Nnamdi Kanu to open his defense and call his witnesses, Nnamdi filed a motion on notice. In that motion on notice, he made 5 prayers to the court. So what are those 5 prayers that Nnamdi Kanu made to the court? We look at them in this video, right? Now, the first prayer that Nnamdi has made is for an order of the court expunging, that's removing, from the records of the courts, the purported plea of not guilty entered for him on 29th March 2025 for reason that same was obtained under deception, coercion, and in clear violation of Section 36 sub 6 sub A of the Constitution of the Federal Republic of Nigeria, and also in clear violation of the directive of the Supreme Court in his case that went up to the Supreme Court. That's prayer number 1. It basically saying, I made a plea of not guilty. You know, in criminal trial, you must make a plea, guilty or not guilty. When you say you're not guilty, it means that the court is allowed to move into trial to hear the case of the prosecution. If you say you are guilty, the court sentences you almost immediately. The prosecution will be called upon to make a summary of your case. The positions of the court will be brought in, and then you are sentenced summarily. But in this case, Nnamdi said, I am not guilty. So Nnamdi is saying that plea that he even made, he made it as a result of deception, coercion, and in clear violation of the Constitution, because he was misled into taking that plea. Okay?
Share this video.
Number 2, he says, an order of court setting aside all proceedings conducted in this trial because the proceedings were conducted based on a defective plea. He said the court should also set aside every other thing, scheduling of defense, witness summons, trial dates, and everything, because it was founded on a nullity ab initio. So he's asking the court to set aside all proceedings in the matter. Some lawyers will ask, is it possible? Me, I will answer by saying, we wait to see. Prayer number 3, Nnamdi is asking for an order declaring that the 7-count charge, you know, Nnamdi is standing trial for 7-count charge, brought under the Criminal Code Act and some brought under the Terrorism Act. So he's saying, an order of court declaring the 7-count charge dated 29th March 2025, declaring that the 7-count charge discloses no triable offense known to law, and he has given reason, having been founded on repealed statutes. You know, Nnamdi keeps saying, where is the law? Show me the law. So he's saying that in prayer number 3, that the courts should declare the 7-count charge as having disclosed no triable offense, because according to him, they are founded on repealed statutes. He has named the statutes here, the anti-terrorism statute, and also he has said that another reason for this prayer number 3 is that it is in flagrant disobedience of the Supreme Court's order for amendment of the charge. Right? Prayer number 4, Nnamdi is asking for an order striking out the charge in its entirety for want of jurisdiction, same being incompetent and void ab initio. We look at prayer number 5. In prayer number 5, Nnamdi is saying an order directing the immediate release, that is, directing his immediate release from custody, there being no valid charge pending before this court against him. So these are the 5 requests, these are the 5 prayers that Nnamdi has presented to the court in the motion of notice that he has filed. Right? Now, he has given 9 grounds to support the prayers that he's making. One of the grounds is that the plea of not guilty was procured from him, forced, right, under pressure, which renders the entire plea taking exercise a nullity. Number 2, that the charge is founded on repealed statutes. Number 3, that by the Constitution of Nigeria, no person shall be convicted of an offense that is not defined by a written law at the time of the commission of the offense. That the prosecution's reliance on repealed laws violates his constitutional safeguards. Right? Nnamdi, in his further grounds, also says that the court lacks jurisdiction to proceed on the charge that discloses no offense known to law. Finally, he says that he has been in custody since June 2021 without a valid charge, and that this is a continuing violation of his fundamental rights under section 35, 36 of the Constitution of Nigeria, and for this reason, he should be set free and allowed to go home. So, 5 prayers to the court. He has supported the prayers with 9 grounds. That is 9 reasons. Now, what's the law on this? What is the law on this? We look at it together. 1, Nnamdi is challenging jurisdiction. And in law, you can challenge jurisdiction at any point during the trial. What the law says, you challenge it before judgment. So Nnamdi has challenged jurisdiction of the court, because those prayers are basically challenging the jurisdiction of the court. So Nnamdi has challenged the jurisdiction of the court before judgment, and the law allows him to do that. You know, some persons will ask, why did you wait till this time to file this motion to raise these issues? The answer is simple. In law, once you are challenging jurisdiction, you are saying that the courts did not even have the power to try that matter in the first place. That everything that the court did is a nullity. So the law allows you to raise the issue of jurisdiction at any time before trial at any time during trial and before judgment. Even on the day of judgment, you can stand up and raise the issue of jurisdiction if you are so sure about it. Even in the court of appeal, you can still raise the issue of jurisdiction. So there is no time frame or time limit for the raising of issue of jurisdiction, because jurisdiction is like foundation of the building. Without foundation, the building cannot stand. Without jurisdiction, no trial in law. can stand. So that's the first legal implication of what Nnamdi has filed. Number 2, the danger, however, is if your motion fails, the consequence might not be sweet. In this case, Nnamdi is relying only on the prayers he has made in the motion paper. Recall that Nnamdi has not filed any defense. He has not entered defense. He has not called anybody in his defense.
Share this video.
What he's basically relying on right now is the motion that he filed, wherein he has raised 5 requests or 5 prayers to the courts. If those prayers fail, the danger is that the consequence might not be sweet. Right? 3, this is why most lawyers prefer not to put all their eggs in one basket.
Share this
What you
video.
do, you enter the defense, you call your witnesses, you tender the evidence, and then also file a motion raising the issue of jurisdiction. More so, if in the course of trial the judge had made a ruling on a no case submission and had said that you have a prima facie case to explain to the court, lawyers would then prefer to go on with the defense and also raise the issue of jurisdiction, so that you don't have all your eggs in one basket. You have, if this one fails, this one, might succeed. This one fails, this one succeeds, and you still achieve what you wanted as a lawyer, to have your client, discharged and acquitted. Now, this is where most of us think that Mazi Nnamdi Kanu should have allowed the services of his lawyers in this matter. They had been with him from the beginning. So many lawyers, Maxwell, Ejimako, remember there was Ejiofor. I think Ejiofor started that matter, that fair, handsome gentleman. He was there. Lots of lawyers have been here. Zokome was here. And finally, he got the services of Kanu Agabi, Senior Advocate of Nigeria, former Attorney General, very intelligent, seasoned lawyer, highly respected across the spectrum.
Share this video.
He got him to his defense. He also got Onyechi Ikpeazu. Onyechi Ikpeazu is one of the most intelligent lawyers Nigeria has today. Talk about election petition. Onyechi Ikpeazu handles election petition for sometimes 5 governors at the same time, flying here and there, and you know what that means. He's also very sound in law generally. So now they had the services of these persons and other persons.
Share
Some
this
of us
video.
believe that he should have allowed them to continue with the trial, with his defense to the end, right? But Nnamdi chose to defend himself, and that's right, that's fine. One has to respect his decision. I respect his decision to defend himself. Nnamdi is convinced that he is right in his decision. That's cool. We have to respect that. I respect that. Okay? We wish him the very best as we await the decision of the courts in this matter.
So, my people, una see am na, matter plenty o, but we are not stopping there. Remember, we happened to have someone talk about Mazi Nnamdi Kanu during his detention in the DSS custody. Let's look at it together. Don't forget to click the subscribe button if you've not done so. Like this video and drop your thoughts in the comments, and I'll be right back.
Well, it was a wonderful experience because it afforded me the opportunity of meeting somebody that is dear to my heart now. That's Mazi Nnamdi Kanu.
Really?
I was detained, and the first day I was brought out, I saw him. I was shocked. So I now went close to him. I said, I am Comrade Atiku Isa. I wanted to introduce myself. I said, no, I know you. So I started telling me about what happened. So I became shocked. Then he told me that I'd be strong. That was how I continued discussion with him for about 2 months. So Mazi Nnamdi Kanu is somebody I know very well, because if you stay with somebody on a daily basis and you are discussing with the person on a daily basis for about 2 months, because in detention you don't have anything to do. You only sit down at a particular spot, and you are with this person on a daily basis, and you are always discussing. So you should know the kind of person that he is. And let me tell you that people don't know that it was prior to my meeting with Mazi Nnamdi Kanu, I had thought that he was a wicked man who want to divide the country, because I am a patriotic Nigerian, and I don't want anything that will bring confusion in this country. So that was the mindset I had. But after meeting him, in the detention, I realized that the Fulanis, the Hausas, the Kanuris there are all loyal to him. You'll be shocked that he has more supporters in the DSS facility than he has outside, because if anywhere you live and you have more than 95% of the people who are supporting you. Before I met him, a Fulani guy told me, because he said, oh, if you see Mazi Nnamdi Kanu, he will like you because you can speak English. The guy does not understand English. We're always communicating in Hausa language, and in Arabic language. So he said, he will like you because you can speak English, and he's a good man. If you have any problem, tell him, he will help you. So that is how they see Mazi Nnamdi Kanu. Or everybody in that detention facility, they see him as their leader. So it's not about a leader agitating for the Igbo cause. He's a leader agitating for Nigerians, for the betterment of Nigerians. So that is the person Mazi Nnamdi Kanu is. So I have discussed with him severally. On a daily basis, he will tell me, Atik will be strong. And along the line, now told me that, okay, I want you to play along so that they release you from here. I don't want you to continue to stay in detention. That was when I said, I'm ready to remain in detention. I said, no, this place is not good for you. Play along. Do whatever they want you to do. Get away from here and go and meet your family. I said, you are here. Say, don't worry. You go out. I don't want to see young men like you to be in detention. So that is the person we are talking about, that Mazi Nnamdi Kanu is. A very passionate leader with compassion, and he has the interest of especially the masses at heart. And I think the problem he has, which is not a problem, is that he's too courageous and fearless. And that is why, to me, he is still in detention. Courageous and fearless.
Now that Mazi Nnamdi Kanu is defending himself, do you think these 5 requests that he has made and the 9 rounds that he used to support it, that the end result of this matter will be freedom, as he mentioned? Let me know your thoughts in the comment section. Of course, we all know the reason Mazi Nnamdi Kanu was in court was to do some filing, which was the motion to stop judgment in terrorism trial. Remember that Justice of the Federal High Court in Abuja, Justice Omotosho, said that come 20th of this month, that he will pronounce judgment to Mazi Nnamdi Kanu's case. So that is why Mazi Nnamdi Kanu moved ahead to file motion to stop the judgment of terrorism. Let's watch this video and I'll be right back.
Oh boy, we not see this one coming. No. Now they cannot go report Federal High Court judge to the appeal court. He say me they stop the man. Remember, say now 20th of this month, now Justice Judge Omotosho talk say he go pronounce judgment on Nnamdi Kanu's case. Kanu don't file motion to stop judgment in terrorism. The cable, Sahara, everywhere. This news they there. Waiting go use for this analysis is coming from Sahara reporters. I don't break out down. Waiting Kanu want. Why he report the judge? Say me they stop him oh. If they no stop him, hey, everywhere go right oh. No go see what he talking. What happened? The detained leader of the indigenous people of Biafra, IPOB, Mazi Nnamdi Kanu, filed a motion on notice. We are going to see the meaning of this. Motion on notice. On Wednesday today, November 12th, 2025, before the Court of Appeal in Abuja. What is the meaning of motion on notice? Motion on notice. A formality request. You use your hand right hand as part of the case. You write hand, okay? Made to the court. You go write hand, go give court. Which must also be shown to the other party, the person where sue you or the person where you sue, before the hearing, before the final hearing, when they walk here. For instance, on the 20th of this month, now he write this motion on notice. He tells them what the applicant That is Kanu wants. What is asking the court to do? Okay? Is asking the court to issue a stay of further proceedings. We are going to check the meaning of this. A stay of further proceedings in his trial before Justice Judge Omotosho of the Federal High Court Abuja. Okay? What is the meaning of this? Stay of proceedings means a temporary stop or pause in the trial until another court. In this case, the appeal court. Another court. Remember, Federal High Court, then appeal court, then the higher. Write it to appeal court to stop this one until they judge the matter. Well, what tell them about what this one they do. Okay? A temporary stop or pause in the trial until another court, in this case, the appeal court, decides an important issue raised by the applicant. Here, Kanu related to the case or to a case. What is he asking the appeal court to do? What did Kanu they ask the appeal court may they do for him? Kanu filed the application by himself, but no be go give them. He filed it through his lawyer, Barrister Alo Ejimako. He wants the Court of Appeal to stop Judge Omotosho from delivering judgment on his criminal case that was scheduled for November 20th, 2025. As they stand so, okay? He's praying the court. He's begging the court, meaning he's formally asking the court to stop the lower court from proceeding until his appeal, waiting he write to the appeal court, is heard and decided. Okay? The exact request, waiting he ask. No, check the exact request. In his application, Kanu asks for an order saying the proceedings of the trial court in case number this, Federal Republic of Nigeria versus Nnamdi Kanu, currently pending before Justice James Omotosho, pending the hearing and determination of the appeal pending against his decision. What is the meaning of this order? We need to check some sentences here like this. Order, pending, to know their meanings. Order here means a legal direction or command given by a judge. The judge should order them. Pending means waiting for a decision, may they decide. So Kanu is saying, pause this case. You have the power, appeal court. You have the power to stop James Omotosho of the lower court, Federal High Court. Pause it, pronounce it, say me they stop until the higher court decide on my appeal. I get something where the appeal for waiting he won't pronounce judgment on. You get the point now? He mentioned three key complaints. One, the court's decision or the no case submission. We are going to check it now. No case submission. No case submission means a claim by the accused that the prosecution has not provided enough evidence to justify continuing the trial. Kanu is saying the federal government of Nigeria, there is prosecutor, has not provided enough evidence to justify continuing the trial. Continuing the trial till 20th, when they want pronounce judgment. They have not actually provided enough evidence to continue this trial. That's what Kanu is saying. 2, the court's refusal to determine its jurisdiction. What is that? Jurisdiction means the legal power of the court to hear and decide a case. Kanu not tell the court, say, see, as far as you are concerned, you don't have the jurisdiction to try me. But they never really decide on this jurisdiction. Kanu is now appeal to the upper court that the court's refusal, they refuse to determine if they have the jurisdiction to try him. Get the point now? Thirdly, and the validity of the counts. We're going to check the meaning of that. The specific charges, under which is being tried, and the court's foreclosure, we're going to check this, of his right to defend himself by feeding witnesses. What is that? Counts here means the individual charges. Charge 1, charge 2, charge 3. What do you do? What do you do? Your offense. Okay? Listed in the indictment or charge sheet. Okay? The validity of the counts, the validity of the charges, the offenses. How valid a day. Okay? Other which is being tried. Because now the charges they use to try person abi. Other which is being tried of his right to defend himself by feeding witnesses. Foreclosure here means, remember, we saw it. And the court's foreclosure, aside this, the court foreclosure of his right to defend himself, they stop his right to defend himself. That's what it's saying. Foreclosure here means the court close or block his right to have, in this case, to defend himself. They block me from defending myself. Feeding witnesses means calling people to testify in your defense. Now that you understand this, let's go back. I believe you understand it now. Listen very well. And the validity of the counts of the charges, are they valid? The specific charges under which he is being tried, and the court foreclosure of his right to defend himself by feeding witnesses. Okay? They stop him from feeding witnesses. Remember the last time we checked this, they give a chance. 1, 2, 3. How many days? He say they must tell her whether they get the jurisdiction and order which law are they trying. He say the law where they take write the charges to die. The judge no gree talk put those ones. He say he go still pronounce judgment on the 20th. Kanu is now writing to the appeal court. Now see, they stop me from defending myself because Kanu is saying until you tell me these two, jurisdiction, the law that backs the charges, I no go do anything. And the court no gree talk those ones. They say they won't pronounce judgment. Kanu is now conclude that I don't close my right to defend myself. You see and so according to the report. 4. His main complaint, the main complaints. Kanu said that even though he raised important jurisdictional questions, the court refused to give a ruling on those points. He said he raised important questions on the court's jurisdiction, but they no gree talk for that one. Okay? Meaning, he questioned whether the trial court, the court, had the legal rights to handle his case. They no talk to seed mouth. He also said the trial judge refused to evaluate the evidence given by the government witnesses. The government, they brought witnesses that the trial judge here, Justice Omotosho, according to Kanu, refused to evaluate the evidence. The evidence when they bring up, he not evaluate them, so evaluate them. Okay? Evaluate the evidence given by the government witnesses in comparison to the cross-examination questions. Meaning the judge should have checked whether the prosecution's evidence was weakened or discredited during cross-examination. When did they cross-examine the witnesses? Now the judge will decide on the evidence of the prosecution or the prosecutor. Okay? Now during that time, say the no one. Okay? 5. On his defense, Kanu explained that he had already submitted a list of witnesses he planned to call to defend him. He know they run away from this thing. But now those things were raised, now he stop him. You get the point now. He told the court he was ready to start his defense. So he told the court he was ready to start his defense. After the judge first decide, make you first decide whether your court had the jurisdiction and whether the charges were valid. These two things. Saying, I already prepared my witnesses where I walk up. I'm ready. But there were two things that stopped me. Those two things were not addressed. It's like he placed a demand before he will continue. But the judge refused to answer them, saying, since no one continue, I will pronounce judgment on the 20th of this month. See, and so he can't go report them now. They do like that. However, the trial court, according to him, refused and said those issues were raised, would only be addressed at the time of judgment. See, so Kanu said, answer these two questions. Once you answer them, then I will bring my witnesses and defend myself. The court said no. Those things you raise, we will talk about them during judgment. When I will pronounce judgment, and that same day, that same time, now we decide them. Can we say no? Before that day, decide them first. May they clear the way for me to start my defense. You get the point now. I want to make you understand. Don't say me I like teaching. It's complaint about fairness. Kanu said the trial court, by refusing to rule on his objections, Kanu's objections, those were raised, has foreclosed or blocked his right to defend himself against the news allegation, very serious criminal accusations brought by the federal government against him. By refusing to rule on those two key points where he raised, they are blocking my way of what? Of defending myself against this dangerous, magnificent, serious criminal accusations against me. The case was then adjourned, meaning postponed to November 2025 for judgment. They say now this date, they go pronounce everything. Hope you are getting it. His fear. What is his fear? From the report, Kanu warned that if the appeal court does not stop the trial court, he might be unlawfully convicted. Unlawfully convicted, meaning found guilty without a fair process. That is why I dey report the lower court to you. Because he was not allowed to confirm whether the charges were valid. The court authority, that is second one, that is one. Second one, the court authority jurisdiction was not confirmed and it was not given a proper chance to defend itself because these were not cleared. They did not give me opportunity to defend myself. 8. Legal reason. He also argued that continuing the case will suppress his right to appeal. As don't say on that day they convict me without this be addressed indirectly, he go suppress his right to even appeal because even after the federal high court don't place judgment say you are guilty, for instance, we don't know which they go talk, he can still appeal. He say if you allow it to continue, man, now the suppression of my appeal be that too. My right to appeal, now they talk so. Okay? Meaning it will spoil or frustrate his ability to challenge the trial court's actions. Okay? In a higher court later. Okay? He used the term fait accompli. This is a Latin legal phrase, meaning something already done and cannot be undone. Something already done. If you allow them to continue, once they pronounce that judgment, it will be difficult to be undone. Cannot undo it. In short, if the trial goes on, a judgment is given, his appeal will become useless because the damage will already be done. Let it now. Go and read it. Now, the final argument. Kanu said that stopping the trial now will not hurt anyone. He said, oh, appeal court to even not stop the trial now. Looking at this point where I don't raise my concern, my complaints, it no go hurt anybody. Not the government and not the court. No go hurt the government, no go hurt the court. Why? It doesn't because the case don't they cease since 2015 and was only revived in 2025. Why hurry? I'm ready to stay in DSS. No go hurt me, no go hurt the federal government, no hurt the court. I beg, stop him. Finally, he complained that granting his request will be in the interest of justice. If you grant my request, that is on the interest of justice. Say, you do the matter well. Meaning it will help ensure fairness and prevent harm to his legal rights. And the matter when Mazi Nnamdi Kanu carry go tell appeal court via his lawyer, hello, say, I beg you, you won't compete me or fail you, come to my head, we get you. What do you think? You could drop off a comment section. Don't forget to like, share, and subscribe to this channel. Thank you.
My people, do you think this new court filing will influence the judgment coming on the 20th? Or was this the right time for him to file a motion, or should he have waited to the scheduled judgment first? Let me know what your thought is in the comment section. If you watch up till now, please don't forget to hit the subscribe button, like this video, and drop your thoughts in the comment section. Thank you for watching.